Imagine a law so powerful that, like, a simple shoplifting ticket triggers indefinite federal detention, and so explosive it is actively tearing apart a major political party.
Yeah, I mean, it sounds like a theoretical law school puzzle, right?
Yeah.
But it is the exact reality unfolding across the country right now in May 2026.
Exactly. Let's do a fast 90-second news hook to show you exactly what is happening here. So, back in January 2025, President Donald Trump signed the Laken Riley Act.
Right.
And this single law completely rewrote the rule book for immigration enforcement in the United States. The statistics are just staggering. Like, by December 2025, federal agents detained an astonishing 17,500 non-citizens under these sweeping new provisions.
Wow. Yeah, that is a massive enforcement number.
It really is. But the shockwaves, they go way beyond the courtroom. They are intensely political. Right now, this specific legislation operates as the central fault line in the battle for control of the U.S. Senate. It is triggering a vicious, a very public civil war within the Democratic Party in Minnesota.
Oh, absolutely.
And just to be totally clear to you, the listener, we are not taking sides today. We are simply reporting the facts on the ground exactly as they appear in the source material provided.
Yeah, and the fallout really is incredible to watch. I mean, we see a profound shift in how the government wields federal power, how state attorneys general challenge that power, and, well, how politicians basically struggle to survive the crossfire.
Which brings us to our mission for today's deep dive. We are going to unpack the specific, sometimes really surprising mechanics of the Laken Riley Act. We will examine how this law hands unprecedented power to state governments.
Right.
And finally, we'll explore why it acts as the ultimate political purity test for the 2026 elections.
So if you were listening to this and wondering how a federal law ripples out to affect, like, local police, state budgets, and a Senate race in Minnesota, we really need to start by looking at the fuse that lit this whole thing.
Okay, yeah, let's unpack this fuse, because before we get to the political explosion, we have to understand the core legal mechanism. Where did all this start?
Well, it starts with a really tragic case in Georgia. Lawmakers named the act after Laken Riley. She was a 22-year-old nursing student murdered by a Venezuelan migrant.
Right, a terrible tragedy.
Yeah, and the crucial detail that drove this whole piece of legislation is that local police had previously arrested this migrant for shoplifting, and then they released him before the murder actually took place.
So lawmakers looked at that specific sequence of events, the prior arrest and the release, and decided they needed a strict federal mechanism to stop it from ever happening again.
Exactly.
So what exactly does the law do to fix that?
It completely changes the rules for detention. The act mandates that Immigration and Customs Enforcement, ICE, must detain certain non-citizens without bail during their immigration proceedings.
Okay.
And it specifically targets crimes like burglary, theft, shoplifting, assault on a police officer, or, any crime resulting in serious injury or death.
Wait, I need to pause you right there, because when I read the sources, the language used around committing a crime really stood out to me. The law targets people who are simply accused or charged, right?
Yes.
Like, they do not need an official conviction by a judge or a jury.
That is the massive shift right there. Yes.
Yeah.
The mandatory detention kicks in immediately upon arrest or charge. It does not wait for a trial. It does not wait for a guilty verdict.
Wow. So to put this in perspective for the listener, it is essentially like a referee putting a player in the penalty box indefinitely before they even review the play to see if a foul actually happened. The law just hard codes the denial right from the start.
That is an excellent way to think about it.
Right.
I mean, let's look at how the system historically worked. Before this act, if local police arrested an undocumented immigrant, that person could ask an immigration judge for a bond hearing.
Right, like standard bail?
Exactly. They could stand before the judge and argue, hey, I have ties to the community, I'm not a danger to anyone, please let me out on bail while my immigration case moves forward.
And the judge decides.
Right, the judge would weigh the facts and make a decision based on that specific person.
A total case-by-case evaluation.
You got it. But the Laken Riley Act removes that bond hearing entirely for these specific offenses.
It just takes the option away completely.
Yeah. It argues that the risk to public safety is just too high, so it strips away the judge's discretion to offer bail. It basically prioritizes immediate mandatory enforcement over the traditional review process.
Okay, so the federal government steps in the second an arrest happens and locks the door. But the law does not just change the rules for the immigrants being detained, right? It actually changes who gets to act as the referee.
Oh, big time.
And this is where the mechanics get incredibly surprising. The power shifts away from federal agents and moves towards state governments.
Yeah, this represents a major philosophical shift in how our government works. The act grants state officials, specifically state attorneys general, the power to sue the federal government. So if a state believes the Department of Homeland Security is failing to enforce these mandatory detentions, the state can drag them into federal court.
But, filing a federal lawsuit usually requires clearing a massive legal bar, doesn't it? A state normally has to prove they suffered real substantial damage to even get a judge to listen.
Normally, yes. But this law lowers that bar to the absolute floor. To sue, a state only needs to prove a minimal showing of harm.
Okay, minimal showing of harm. What does that mean?
Well, the text of the law defines that harm as financial damages as low as $100.
I'm sorry, what, $100, as in $100 total?
Yes, $100.
How does the state government even quantify $100 of harm from a single immigration decision? That does not even cover the cost of the printer ink to print the lawsuit.
Yeah, well, that is exactly the point. It's designed to be a non-barrier. Think about how a state operates, right? If a local police department spends 1 hour of administrative time processing a piece of paper, that costs the state $100 in wages.
Oh, wow. I see.
Or if a local hospital provides a basic checkup, that is $100. By setting the threshold at a mere $100, the law essentially gives state attorneys general a blank check to legally harass federal immigration judges.
So Texas or Florida could just watch federal dockets, see an immigrant released on parole, say, hey, that cost us $100 in paperwork, and boom, file a federal lawsuit to stop it.
Yes. And the legal practice alerts from Texas show that state officials are highly motivated to use this exact tool. They constantly monitor these federal releases.
But wait, what if a state thinks a detainee actually should be released? Let's say ICE detains someone and the state government wants them out. Can the state sue the federal government then?
No, they cannot.
Really?
Yeah, and this is what legal scholars call an asymmetric or one-way challenge system. The pressure only flows in one direction. States hold the power to sue if the federal government releases a detainee.
Right.
But they hold absolutely no power to sue if the government decides to keep them locked up.
So the system is just hardwired to default to detention. The state looks over the shoulder of the federal judge and they hold a megaphone that only yells, keep them locked up.
Precisely. It strongly incentivizes maximum enforcement.
Okay, so we have a legal net designed to catch violent offenders, and it empowers states to aggressively enforce that net. But laws written this broadly often catch things they never intended to, right?
Oh, good one.
Let's look at the collateral impact, because when you read the practice alerts from the Texas Immigration Law Council, the real-world scenarios are jarring.
They really are. We need to look at how this actually plays out on the street. Consider a hypothetical scenario outlined in the legal alerts involving a man named Roy.
And just to clarify for the listener, the sources note Roy is a DACA recipient. That means his parents brought him to the United States as a child, and he grew up here with legal protection from deportation.
Correct. So Roy gets into a serious traffic accident, and tragically, the other driver is killed. Now, according to the outline of the scenario, Roy is completely at fault for the crash. He made a driving error.
Right, an awful accident.
On top of that, his driver's license is expired. So the responding police officer gives him a citation for driving with an expired license.
Under normal circumstances, an expired license citation is a super minor ticket, right? You pay a fine and you move on.
Under standard local criminal process, yes. But look at the strict wording of the Laken Riley Act. It mandates detention for offenses related to an incident resulting in death.
Oh, man.
Because the minor ticket ties directly to a fatal accident, Roy now faces mandatory, indefinite ICE detention.
His DACA status doesn't protect him.
Not from the detention mandate. The federal immigration process supplants the local criminal process completely.
Wow. Let's look at an even more extreme example from the sources. We have a scenario with a woman named Linda. She is an undocumented mother.
Right.
She is standing at the supermarket checkout line. Suddenly, her toddler runs out the automatic doors toward a busy parking lot. Linda panics. She sprints after her child to grab them, but she happens to be holding a gallon of milk she hadn't paid for yet.
So a supermarket security guard stops her outside. The police arrive. And because she carried unpaid merchandise out of the store, the officer cites her for shoplifting.
Just for the milk.
Yeah. Now, the value of a gallon of milk is what, $4 or $5? In the criminal justice system, this is a Class C misdemeanor. It is the absolute lowest level of offense. Normally, she gets a ticket, promises to show up in court, and goes home to her child.
But the Laken Riley Act explicitly targets shoplifting.
Exactly. The act does not distinguish between stealing a $5 gallon of milk during a panic and organizing a massive retail theft ring.
Right.
Because she is charged with shoplifting, Linda is immediately subject to mandatory indefinite federal detention. She gets no bail. And remember, in the federal immigration detention system, you do not possess an automatic right to a government-provided lawyer like you do in standard criminal court.
So if you are listening to this, contrast the reality of Linda's situation with the stated intent of the law. Lawmakers named the bill after a murdered nursing student. They wrote it to stop violent criminals from slipping through the cracks.
Right, public safety.
But the strict letter of the law means federal agents indefinitely detain a mother over a gallon of milk. The gap between the intent and the application is massive.
And that massive gap is exactly what ignited the political explosion we are seeing. When politicians cast their votes for this law, many of them simply wanted to show they stood tough on crime.
Sure.
They did not anticipate the headlines about mothers detained over milk or the harsh statistic of 17,500 people locked up in a single year.
Which brings us to the absolute front line of the 2026 elections. Because in places like Minnesota, this isn't just a theoretical legal debate anymore. It is actively ending careers.
Oh, completely. Minnesota provides the perfect case study. It shows us how immigration evolved into an unforgiving purity test. Right now, the state hosts a highly contested Democratic primary for an open Senate seat because Senator Tina Smith is retiring.
Running to replace her is Representative Angie Craig. She built her career as a moderate Democrat. Back in January 2025, she actually voted for the Laken Riley Act.
Yes, she did.
She joined 45 other House Democrats who crossed the aisle to vote with Republicans to pass the bill.
And, at the time, that vote made strategic sense for her. She represented a swing district. Voting for border security measures played well with her moderate voters, and she proudly touted her bipartisan credentials.
But then the reality of the law hit the news. The 17,500 detentions became public, and suddenly she is running for a statewide Senate seat, desperately needing the support of the progressive base. So she executed a massive pivot.
She went into full damage control. She publicly stated she regrets her vote. She called to defund ICE. She even went as far as introducing articles of impeachment against the Homeland Security Secretary Kristi Noem.
But progressive voters see right through it. We read a very active Reddit thread from Minnesota voters in our sources, and they are not buying the pivot at all.
Not even a little bit.
They're calling her AI pack Angie and comparing her to politicians famous for waffling on issues. They point out she only flip-flopped after her internal polling numbers dropped. One voter wrote, "I think she meant to say, I regret that my vote has damaged my political future."
They accuse her of pure political calculation. And this tells us something critical about why immigration acts as the ultimate wedge issue.
Yeah.
Voters view it as a moral absolute.
Yeah.
For a progressive voter, voting for mandatory indefinite detention means you endorse stripping away basic human due process. A single vote shatters your entire moderate brand.
And the anger is not just angry comments on the internet either. The establishment is turning on her. The retiring Democratic Senator, Tina Smith, originally promised not to pick a successor.
Right.
But she just formally endorsed Craig's progressive primary challenger, Lieutenant Governor Peggy Flanagan.
And Senator Smith specifically praised Flanagan as a progressive fighter who holds the necessary conviction to confront the Trump administration's immigration policies. She essentially told voters that Angie Craig cannot be trusted to hold the line.
Meanwhile, Republican strategists are just sitting back and enjoying the show. They actively weaponize Craig's flip-flop. They use the chaos to boost their own candidate, Michelle Tafoya.
Right.
The GOP strategy relies on this brutal Democratic infighting. They want the Democrats to exhaust their campaign funds and alienate their own voters, hoping it hands Republicans a crucial Senate seat this November.
It forces us to ask a really difficult question about political survival. Does a politician like Angie Craig actually regret the severe policy impacts of the Laken Riley Act? Or does she just regret that her constituents got angry enough to threaten her job?
That is the million-dollar question right there. And it highlights how this law eliminated any middle ground. If you are a Republican, voting against this act means you are weak on crime.
Yeah.
If you are a Democrat, voting for it means you are complicit in authoritarianism. You must pick an extreme side.
There is absolutely no center left. None.
Okay, let's bring all of this together and summarize what we uncovered today. The Laken Riley Act fundamentally shifted the reality of immigration enforcement in America. It mandates indefinite federal detention for non-citizens merely charged with certain crimes, sweeping up everything from fatal accidents to minor shoplifting.
Right. Furthermore, it transfers unprecedented power to state governments. State attorneys general can now sue the federal government over release decisions using an asymmetric system that only requires a laughable $100 showing of harm to force a detainee to stay locked up.
And the real-world result of 17,500 detentions has boxed centrist politicians into an impossible corner, completely reshaping the landscape of crucial 2026 races like the Minnesota Senate election.
We always say that knowledge matters most when you can actually apply it. Whether your priority is protecting due process, securing the border, or simply tracking who will control the United States Senate next year, you must pay attention to this single law.
Absolutely.
It acts as the invisible hand shaping all three arenas simultaneously.
Everything traces back to this specific legislation. So we want to leave you with a final thought to mull over. We talked about that $100 threshold for states to sue the federal government.
Yeah, the printer ink threshold.
Right. If state attorneys general can now successfully use a $100 administrative cost to legally hijack federal immigration decisions, what stops them from expanding that tactic?
That is a scary thought.
Could this exact same legal framework soon be weaponized by states to seize control of other purely federal responsibilities? Could a state soon sue the federal government to block environmental regulations, disrupt international trade agreements, or even interfere with military deployments, all by claiming a tiny $100 inconvenience?
The precedent now exists.
It does. We started with a minor shoplifting ticket, and we arrived at a fundamental shift in federal power. The shockwaves are only just beginning.